Badlands running to Badlands. Explain those Badlands. That's a hell of a name.
Okay.
Well, good afternoon, everybody, and welcome to the Daily Herold here on Badlands Media. I am your host, John Herold, and I think I got a pretty good show lined up for you guys today. I know Ash is live right now doing The Choice with Ghost and General Quast, but she's going to be joining me afterwards to talk about the Tina Peter case. There's been a pretty major development, I would say, one that's looking pretty good for Tina, and she's going to give us the rundown. She was in the courtroom when that went down yesterday. So very excited about that. We also have all sorts of just random news stories, Trump hinting at the Insurrection Act, some economic stuff, and then whatever you guys in the chat want to talk about. Rocky Top Apologist, I'm always driving when this show is on, so it's tough to offer pithy comments when needed. And this show begs for pithy comments. Yes, it does. I do beg for pithy comments. No raid from The Choice. Looks like they're raiding right now. So let's get a quick word from our sponsors, and then hopefully Ash will be on by then, and maybe we'll start with that. But we'll see. We got MyPillow up first.
I'm excited to announce that we're having our biggest Made in America sale ever. We just put huge discounts on products made right here in the USA. MyPillow bed pillows, body pillows, go anywhere pillows, bolster pillows, all made with my patented adjustable fill. Mattresses, mattress toppers, mattress pads, adjustable bed frames, mattress foundations, and so much more. All made right here in the USA. And now we're expanding our USA products beyond just quality sleep. Like the cross I wear every day, now available in both men's and women's. We even have USA-made socks. And are you tired of being tired? Try our new health beverage, Rev 7. Or how about my coffee, the greatest coffee ever. So go to MyPillow.com or call the number on your screen. Use this promo code to get deep discounts on all these products. Plus, for a limited time, your order ships absolutely free.
Tired of being tired? Get some MyPillow. Use promo code Badlands. We also got BadlandsHealth.com, Unicity, supporting the show today.
You deserve more than sluggish mornings and blood sugar spikes. Discover the simple daily system that helped so many regain health without dieting or exercise routines. 2 easy-to-take daily drinks. A brain-boosting, appetite-suppressing morning blend that ushers in energy and clarity. A hearty, fiber-packed pre-meal drink that stabilizes blood sugar, aids digestion, and fights cravings. It's a gentle, science-backed path to improved metabolism, renewed vitality, and lasting weight control. Feeling better starts with this simple 2-step daily protocol.
BadlandsHealth.com. I drink this stuff every single day, except I might not soon because I think I'm almost out. So we could just wait in silence for Ash to get here, which I'm totally down to do if you guys are. Or we could probably start plugging away. Let's see what we got. Doge, no update on the website there. Silver prices are back up a little bit. They were down to like $88 last night. A little short of record high, but getting there. River, Bitcoin, badlandsmedia.tv/river, 96.5. Good stuff there. A couple things on the presidential website. We talked about these last night on the Power Hour. There's some import stuff having to do with semiconductors and rare earth critical minerals. I think this coming on the heels of that meeting Besson had with all those leaders from around the world. I think it's a little more notable. And there's also this whatever this is, this keeps popping up. Establishing a second emergency board to investigate disputes between the Long Island Railroad Company and certain of its employees represented by certain labor organizations. I think this is like the second or third time there's been something along these lines with this dispute that's popped up. I haven't done any reading into it, but I almost feel like I should now because it keeps popping up. Oh, Ashley, she's going to grab more coffee and then join. That was 4 minutes ago. How far away is her coffee pot from her computer? Can't be more than 2 minutes away. She must be making some pit stops along the way. Trump did have this video. Maybe this is kind of long. We should probably wait. He's unveiling his great healthcare plan to lower costs. Can't imagine it's really that great, but we'll talk about it after Ash. I have no idea how long Ash will be on the show because she's a talker. She's well researched, and this is a pretty interesting topic. So I don't know if we'll even have time for that. We did have this yesterday. A federal officer shot somebody in the leg after being attacked during a Minneapolis arrest. It was kind of popping off in Minneapolis yesterday. Federal officer shot a man in the leg in Minneapolis after being attacked with a shovel and a broom handle while trying to make an arrest Wednesday. Smoke filled the street near the site of the shooting as federal officers protesters squared off. A group of officers wearing gas masks and helmets fired tear gas and grenades into a small crowd while protesters threw snowballs and chanted "Our streets." I think it would be pretty epic if there was like a massive snowball fight between ICE and the protesters. Such scenes have become common in the streets of Minneapolis since immigration agent fatally shot Renee Good on January 7th. And that led to Trump posting a few things on Truth Social. First we had, let me find it. First was this one. Highly respected judge declined to block ICE operations in the very politically corrupt state of Minnesota. ICE will therefore be allowed to continue its highly successful operation of removing some of the most violent and vicious criminals anywhere in the world, many of them murderers from the state. The great patriots and law enforcement will continue to make our country safe. Record low crime numbers. Good stuff. And then this is the doozy. If the corrupt politicians of Minnesota don't obey the law and stop professional agitators and insurrectionists from attacking the patriots of ICE, who are only trying to do their job, I will institute the Insurrection Act, which many presidents have done before me, and quickly put an end to the travesty that is taking place in that once great state. Thank you for your attention to this matter, President Donald J. Trump. Now, one thing I did find interesting, I was doing a little digging on, I got to find this guy now. Okay. So when a president's going to make a decision like this, like invoking the Insurrection Act, he usually gets some legal feedback from a whole host of characters, the Attorney General, his advisors, and then the Office of Legal Counsel. And there's also, let me make sure I have this right. Yeah, Office of Legal Counsel. Now, if you guys remember from my Devolution series, I've talked about this before, and I've done a lot of research because in my part 25, where I talk about the presidential emergency action documents, there's these committee appropriations hearings, and then it takes you to these documents here where they talk about how many PEDs were active, approximately 56. You guys remember this article, my part 25. Current 56, current 56, current 56, current 56, and then approximately 56. A change in wording. Okay. Office of Legal Counsel, I think, is a pretty important position. They deal with the PEDs, they deal with all sorts of stuff. And when you look at who Trump would be, getting advice from, his current, the person in charge of the Office of Legal Counsel right now is this guy named T. Elliot Geiser. Super young. He's only a year older than me. This is the U.S. Assistant Attorney General for the Office of Legal Counsel. This is who Trump would basically probably have to get like legal approval from. Not that he needs it, but legal counsel from in terms of implementing the Insurrection Act. And if you look into this guy, he was based as hell during the 2020 election. He was all up and down. He was the one who was saying like, yeah, Vice President Pence, he could totally, stop the election from happening. Not that I agree with it necessarily, but interesting character. And with that, Ash is in the chat. Let's bring her in. What's up, Ash?
Hi.
We are. I watched a little bit of your show. It was good.
Oh, you did? Yeah. What did you disavow?
Ghost referred to me and Burning Bright in the field or something.
Oh, it's James and John. Yeah.
Yeah.
Well, so James says to Burning Bright, like,
James says to Burning Bright.
James says to Burning Bright. James says to John, you're James in this scenario. He's dead at the beginning, though. No offense. But he says, well, you're no threat to anyone intellectually or physically. And I was like, oh, I get it now. I see how you're
That's
putting
funny.
those two in
I like that.
that context. That was a
But
good
yeah, I
show with
encourage you
General
guys to
Quast,
all
though.
go do that watch that show with General Quast. It's a great series you guys are doing. Let's talk about Tina Peters a little bit, because yesterday there was a pretty massive development. I've watched all the videos that CanCon put out, but you were in the courtroom when this happened. So do you want to give us a little rundown of what this hearing was for? Like, what happened? What do you think's next? Just start splurging.
Sure. So so, as I said to you guys yesterday in the back channels, I think that our audience is the most well-informed audience on the matter of Tina Peters, because the appellate court yesterday was forwarding arguments that Brian and I have been making since her trial and since she was sentenced. Egregious developments. And it's important to note that the most explosive stuff that came out of this hearing had nothing to do with Tina Peters' defense. The defense counsel and the arguments that they were putting forward, and the theories involved in their briefing on this case. These were things, excuse me, that the appellate court, 3 judges, they brought them because they have real problems with how this case went down. And that's very encouraging, because there are real problems with how this case went down. That's what Brian and I have been talking about since August of last year. And
so Tina's attorneys appealed.
Yeah. So
Like,
Tina,
this
was the appeal of her criminal conviction. So this is the actual appeal of the jury conviction, is what this hearing was.
Okay. Gotcha. And this
Now,
is the first time the appeal's been heard?
Yes.
Okay.
There's been a number of other appeals, right? She appealed to federal court on a habeas motion, let me out of prison while I'm waiting for appeal. We covered that when it happened. There's been other motions as well. There was a motion on Christmas Eve about the presidential pardon. It was a motion to vacate jurisdiction for the court, this appellate court, to vacate jurisdiction based on the presidential pardon, that they don't have jurisdiction any longer to hear this case because the president has pardoned her. They didn't rule on that. And one of the things I was a little bit surprised about, it might just be a timing thing, right? They only had 30 minutes per side. But after everything we watched to get that pardon in place and to get that before the court and to have that be a thing, Tina Peters' side decided not to spend time on it yesterday. Peter Tickton stood up at the beginning and said, we're not going to spend any of our time on the Christmas Eve motion, which is the motion to vacate jurisdiction. If it comes up, we'll argue it. And it did come up a little bit. But it was an intentional decision of theirs not to. Now, I think legally it was the right decision, because the appeal, there are many legitimate reasons that this should be overturned.
Yeah.
There was open bias in front of the jury. She was not allowed to talk about her intent to the jury, but the state talked about her intent to the jury.
Yeah.
There was a misdemeanor that was, treated as a felony, and everybody's just okay with it, right? There's a whole bunch of things that are real problematic in this.
Can you explain that one? Because that was one of the more interesting ones from the videos that CanCon showed, and maybe I should just play
I have
the
that
videos.
clip if you want me to play it.
Let's play that clip and then have you explain a little bit, because even I was a little confused by how that went down, the whole misdemeanor and felony thing.
Let me make sure I have the right one. It's the 3-minute one. Is this the 3-minute one?
Is it your position?
Yeah.
This isn't the omission of an element. This is a misinstructed jury. How can we?
Is it your position that a person can still be convicted of a crime with which they were never charged and with which the jury was never instructed, as long as the evidence is sufficient?
Yes, I think that is what the case law indicates, that if it's just in this case, I'll just point out too that, I don't have the language of the statutes that you're citing in your hypothetical, but it was one word, might, and it was already.
Yeah, but that one word distinguishes it from a felony to a misdemeanor.
And this case made an extra sentence.
Can you pause it there for a second?
In the Department of Corrections.
So what exactly went down here? Like, they're talking about this word might, and I feel like I'm just missing a little context to make this make sense.
So there are 4 felonies involved in this case. And it's all the same act. It's the same. She refers to it as the plot of deception.
Yeah.
It was Conan Hayes was at the trusted build, and the public officials at the trusted build were told that he was Jerry Wood. They used the credentials of Jerry Wood to get Conan Hayes in there so he could observe, and that forms the 4 felonies that Tina was convicted of. That's it, by the way. Never images or touching election machines or any of that stuff. It was the representation of Conan Hayes to Jerry Wood. And what they're saying here is that the way that this was presented to the jury was as a misdemeanor. It is in the indictment, I believe, is a felony, but it's using the language of the misdemeanor. The jury was heard a misdemeanor, convicted of a misdemeanor, but they're saying there's a clerical error. It should have been a felony. The court is not accepting that argument. So the fourth felony is conspiracy to commit criminal impersonation.
Mm-hmm.
And that's the one that they're talking about. And the word might in the statute, I think it's like might or shall is the distinction, right? There's the different, and that one word distinguishes the crime from a misdemeanor into a felony. And they charged they sentenced her on a felony that the jury never heard. The jury heard it as a misdemeanor. They're saying, that doesn't really matter.
That's the part I'm confused about. So the jury looked at it and they found her guilty of the misdemeanor language.
Yes.
But then when it came to sentencing, they sentenced her based on the felony evidence or the felony.
So the indictment was a felony, but the language within the indictment is misdemeanor language.
Gotcha.
And the language that was presented to the jury was misdemeanor language. And they still want to, like Judge Tao there saying they gave her 15 extra months that they can't give her. In fact, we could probably just go back
finish the clip.
that part. Yeah.
That couldn't have been given had it been a misdemeanor conviction. Couldn't have been given had it been a misdemeanor conviction. It clearly affects a substantial right.
And I'll just say, I'm confused as to why the people are continuing to maintain that the proper remedy on this isn't to enter the conviction for the misdemeanor, because the indictment used the word might, and the jury was instructed on that. So that's what the verdict is. I am baffled as to the position that's being taken that we can somehow overlook that and still enter the felony because the evidence that was presented at trial would have supported the felony. Are you still maintaining that position in front of us here today?
Yes, that is our position.
What case law supports that argument?
I'm sorry.
What case law supports that
I've
argument?
cited it in my brief. I don't have it right in front of me, but the case
It's the omitted elements
Yes,
case law,
correct.
right?
Mhm.
But that's just where the element was omitted, and but the element that was omitted wasn't in dispute. Here, the jury was affirmatively misinstructed. It was instructed on the misdemeanor, and it found her guilty of that misdemeanor beyond a reasonable doubt. This isn't the omission of an element. This is a misinstructed jury. How can we correct that by saying, no, we'll just assume that because she could have also been convicted of the felony, we enter that even though we don't have a jury verdict? That's a...
I understand it's a difficult position
Okay.
for the people to be in.
It's not a position you have to take.
But I
need to pause it there for a second because so I'm baffled by the fact that the state isn't correcting this. They can't. Tina Peters, I was on a Twitter space talking about this last night. Tina Peters is the pin holding this whole thing together. If you pull it out, it's all gonna crumble to the ground.
Holding what together?
I'm thinking of like one of those, those like artsy kind of things that they put together, and they're like, art installation that's all a bunch of pieces coming together, and there's one piece, and if you touch it, the whole thing shatters to the ground. I don't know if this is coming through in the way it is in my head, but
like dominoes, maybe.
But their narrative, their story. So Tina Peters isn't just punished because she, touched election machines or something. They took a single misrepresentation, turned it into 4 felonies, did not allow anybody to question it. The media carried the state's narrative entirely, and then they used that narrative to change the law. They took power out of the counties and centralized it in the hands of the Secretary of State in the Colorado Election Security Act 22-153, based on what Tina Peters did. That act could have been called the Tina Peters Act. 8 years and 3 months of her 9-year sentence are these felonies, these 4 felonies, the felonies, and one of them shouldn't be a felony, as we just heard, right? The other 3 are Conan Hayes was introduced as Jerry Wood. Nothing to do with election machines at all. And this is what Brian and I have been screaming from the rooftops for over a year now, is that everybody still says she's a hero, she saved our elections, or she's a demon, she, threatened our elections. And the reality is that this case and what the state did in this case has nothing to do with elections at all. But the story of it, The story of Tina Peters and elections has been used to weaponize the government against all of us in the state.
Yeah. That's wild. That's wild.
Yeah.
Let's finish this clip. And then I know there were 3 really good clips that Brian put out. One of them was like really long.
The 9-minute one is really long, but it is a really good clip.
I know. Maybe we can go through some of it.
Yeah.
Let's finish this one though.
Thank you. But I do believe that the omitted element language applies because to me, I understand, I can hear from the way you're talking about it, it seems more egregious to add this extra word than it is to omit an element. But to me, omitting an element is a pretty big deal. And the fact that can be
except in those cases originally charged with the elemental language. Here, never on the table.
That is true. But if I can just add, and again, it seems that I will not be able to convince you, but I just want to put my argument out there, which is that there wasn't a confusion from the parties about what they were talking about because the correct statutory citation was used. So they were on notice of the statutory citation. The language was incorrect, but the statutory citation was correct.
Couldn't that also mean that the prosecution was on notice that they'd only charged, since the language was correct, they'd only charged that language and not, both of them were on notice of something wrong.
Oh, yes. I guess what I'm saying, Your Honor, is just that there wasn't a notice problem because there was the statutory citation. And the parties treated it as though, I think it was an oversight. I think everybody believed that if they had charged and used the language for that's felony. What the record bears out, in my estimation.
Yeah. So, and it's important to remember, this is the state talking. She's an assistant attorney general, out of the attorney general's office. She has been, as I recall it, the AG delegate person to speak for Secretary of State stuff for a long time, since Chris Beall left AG's office in 2021 and became the Deputy Secretary of State. I remember her being kind of the point AG person for Secretary of State, for speaking on Secretary of State cases, matters, questions. And she was on her heels. She was definitely caught off. They were not expecting, the state was not expecting the court, and I think in part because the legal work of the Tina Peters side has been sort of chaotic and all over the place in terms of what their strategy is and what they're pursuing. It's bounced around quite a lot. I don't think any of us were expecting the court to come so locked and loaded. The court has real problems with how this case was tried. And that's incredibly encouraging because we have real problems with how this case was tried. They don't have anything to do with politics or elections. They have to do with due process. And our system prioritizes the rights of the accused. And you hear this state prosecutor, assistant attorney general saying, it was an oversight and we accidentally gave her 15 extra months and felony and whatever, but it's fine. It's no big deal. And you hear her repeatedly yesterday. I would encourage everybody to watch it or just watch the clips Brian put out. Those are the top moments. But you hear her repeatedly talk about how the violations, and there are several, of Tina Peters' due process rights don't really matter because the state is super justified in what it was doing. And, she kind of opened the door to its own. Yeah. In the sentencing, especially in the sentencing, that's the 9-minute clip, which I just think is absolutely fantastic. Maybe let's speed it up.
Let's watch it. Just let's skip the parts maybe from you guys talking, because isn't that spliced in there too?
That's in there too, I think. Yeah, we can definitely do that.
Yeah.
Right. And I'm going to make it like 125. We'll see how that does.
Okay. I don't have to talk about other news today. You can stand for the whole show.
All right, I just started playing it. Let me back it up to the beginning again.
Okay.
That one, yeah, okay.
So the trial court in sentencing referred to Ms. Peters peddling snake oil that's been proven to be junk.
You're no hero, you abused your position, and you're a charlatan who used and is still using your prior position in office to peddle a snake oil that's been proven to be junk time and time again. You abdicated your position as a servant of the Constitution, and you chose you over all else. Yes, you are a charlatan, and you cannot help but lie, as easy it is for you to breathe. You betrayed your oath for no one other than you. And this is what makes Ms. Peters such a danger to our community. It's the position she held that has provided her the pulpit from which she can preach these lies, the undermining of our democratic process, the undermining of the belief and confidence in our election systems. It's not about questioning it. No one says you can't question, you can't ask. It's completely different. And if you don't understand that distinction, then there's nothing I can say or do here today that will change your mind.
We started this podcast off going over the Mesa 3 that
and she was.
This is
Okay.
The trial court in sentencing referred to Ms. Peters peddling snake oil that's been proven to be junk. She tried to undermine the election and she was weaving tales. Didn't he consider uncharged conduct as he referred, given the references to snake oil, et cetera? Wasn't he considering uncharged conduct in sentencing her? And wasn't that an error?
Well, are we talking about the First Amendment issue? I'm not sure that that is, one, it hasn't been raised, but I understand that it's a concern to the court. I don't think that that's something that's problematic. I mean, all of that was part and parcel of is the context
First
of
Amendment
state of
issue?
Colorado.
conduct. She wanted to promote these allegations of election fraud, and her scheme of deception, everything she did.
But she wasn't convicted of publicly saying it was election fraud.
Correct, but
I was bouncing up and down in the back of this courtroom while this was happening. I was like, I cannot believe they're asking these questions.
I think because it's the context, it's
It is
relevant. I
shocking.
think it's something
You should pause for a
Why is the
second here
context
because
relevant when the court?
this is wild. So you were here, you were in the back or whatever, but the fact that this is coming from Colorado appellate court, like that's shocking to me.
Yes.
Do you know the makeup of these guys? Are they Republican?
I don't. I'll tell you what, I thought that they were seemingly hostile to both sides yesterday, but very interested in the due process rights of Tina Peters and how this played out. It is clear to me and to Brian, and we've been talking about this for a long time, that Tina Peters is a trophy. She's a trophy for both sides. They both want to win the trophy, right? She's either Joan of Arc or she's Osama bin Laden. And that's where they want to, we didn't see any of that from these judges. We saw, I think the judges were pissed off at both sides of the shitty legal work. I think we saw that in the federal appeal on her habeas as well. I think that judge, and the federal judge, was Tina's greatest advocate in that forum. Right. Now, ultimately, he said he couldn't rule on it because this still hadn't happened. And he federally can't rule until the state options have been exhausted. So this has to happen before you can do anything in federal court. I think that's right. I think that's legally sound. But that judge also had real problems with how this case went down. These judges have real problems with how this case went down. And they were pissed and they were hostile towards both parties, not because of any argument raised by the defense or by the state. Because they've read the record. At several times, Judge Welling in the middle, he says, oh, no, I've read the whole thing. Like, you don't have to recap sentencing for me. I've read every word of it, right? I've dug into every single aspect of this. The judges were very prepared and they have real problems with how this case was actually tried in the trial court. I think Tina Peters gets relief at the end of this. I really do.
Oh, well, I'm curious. I do want to get to that, like where you think this is going, but I'm curious about how they were hostile towards Tina's side, because we haven't really seen any of that. I've only seen clips of them being hostile towards the state, like what were they doing towards Tina's attorneys?
Oh yeah. So John Case went first because Tina's the moving party, right? So he got to go twice. He got to go first and then have a rebuttal afterwards. So this is the middle where they're talking to Lisa Michaels. In the beginning, so I mentioned Peter Tickton stood up and said, we're not going to spend any time on the pardon issue. And the justices were like, okay, that's fine. And then John Case gets up to speak and he starts with, what was Tina to do? What was she to do? He doesn't get two sentences out before these guys jump in and are like, well, hang on a second. You're saying that she had a federal duty to preserve election records. She did preserve election records before the trusted build. She took the forensic copy. Now, Mark Cook has a video out and will say that forensic copy still doesn't preserve everything that needs to be preserved. Even the records that Tina took, right? The images that she took does not preserve things like the BIOS. And so it's still insufficient. But according to the court yesterday, isn't her federal duty discharged because she took the records, right? She preserved them in the first instance before the trusted build, and that satisfies her federal obligation to preserve the records. She has them now, right? His judge on the end with the white hair, that's Judge Lipinski, on the left side, or on their left side, stage left. He gets into, with the state lady, all means all. So it's not just we have a record so we can destroy the actual records because we took a copy of them, right? Like you can't draw those lines because the statute doesn't let you draw those lines. All means all. Again, not an argument Tina Peters' side has ever made. an argument that the court made that was some of the most sound legal reasoning we've heard in this case. That was what was most surprising to me, was the arguments that Brian and I have been forwarding for over a year since the trial and since the sentencing that we had real problems with, right? We're not lawyers. We're looking at this and wanting that we want free and fair elections, but this case has never been about elections. Everybody wants to make it about elections because, again, Joan of Arc or Osama bin Laden, and that's that most important scalp in Colorado. Elections get fixed if Tina Peters gets out, right? Like that's kind of the false binary that we're trapped in the matter of Tina Peters. The real issue here is her due process rights were trampled on. The Constitution and particularly the Bill of Rights was used as toilet paper when it comes to Tina Peters. And they all said it was fine because, election denialism and threats to democracy are just so bad that, you heard Lisa Michaels, I don't think it's really all that problematic. It's not terribly problematic. So John Case, when he said, so at the time that he sat down, we're 28 minutes in, the court stops him and says, hey, you have 2 minutes left. Are you sure you don't want to save some time for your rebuttal? And he's like, oh yeah, I'll do that. So he sits down. Then
the court told him to do that.
Yes. At that point, 28 minutes into their 30 minutes, this is Tina Peters' appeal of her criminal conviction and sentencing. The decision the thing we've been waiting for well over a year for her to have her day before the appellate court. 28 minutes into their 30 minutes, we have not talked about sentencing at all.
No way.
Yeah. And you heard in that clip, Matthew Barrett's sentencing calculus, right? Snake oil and all he never let her talk about the snake oil. He never let her talk. He never let it come in, the snake oil, right? But he invoked it in sentencing and used it as reasoning for why she needs the book thrown at her, because she's such a danger because of the snake oil that she might peddle.
Well, how did it get brought up then? Because the three judges in those other clips that we've seen, they're talking about the sentencing and all that stuff.
Judge Lipinski brought it up. So John Case sits down. He's got 2 minutes left on the clock. They bring up Lisa Michaels, rip into her for about 15, 20 minutes. And then Judge Lipinski, the white-haired guy at the end, is like, can we talk about sentencing? And Judge Tao is like, well, actually, I need to talk about the fact that, this misdemeanor felony thing. So then they spend more time on that. Then they finally get to sentencing because the court wanted to talk about the sentencing problems.
And Tina side didn't bring it up at all.
Didn't bring it up at all. Then they end up spending 9 extra minutes or 7 minutes. So it was a total of 7 extra minutes with Lisa Michaels. So they give John Case 7 extra minutes. So he has 9 minutes instead of 2. And then they deal with the sentencing stuff. Crazy.
Well, let's listen to more of this, this 9-minute clip here.
Excluded much of the evidence of election fraud. So on one hand, the judge says, Ms. Peters, you can't bring this in. On the other hand, he refers to it when he's sentencing her.
Well, and again, I know the court is aware of this, but if I just want to make sure the record is clear that he didn't exclude it entirely. He limited it. But also she spent a great deal of time at the sentencing hearing talking about this election fraud. She used it as a platform to make all of these allegations. So of course it was relevant to what the court was doing at the sentencing hearing. The court was entitled to consider what she said.
Well, then let's turn this as a First Amendment issue, is that the court's entitled to consider the larger context, but there's some limitations to that, right? The court cannot punish her for the exercise of her First Amendment rights. Isn't that a fair statement as a broad principle?
I think that's correct. I mean, if the court can consider the conduct and it may factor into the sentencing, just to break that down a little bit. I mean, I think the broad proposition is correct that we can't punish people except in these circumstances, which we're not talking about right now. But I think to the extent that it is relevant then the court can consider it and factor it into its sentencing decision.
But that's the question: is does her political or personal views is it relevant, or is it something that is inappropriately considered? And I guess I would also frame it as, in defending the convictions and what testimony was brought in at trial and what defenses she could assert, the people very narrowly tailor this to: we're not talking about her election conspiracy stuff. We're not talking about making the copy before, making the copy after. We're talking about this very specific conduct of misleading the Secretary of State and the like. But then at sentencing, the sentencing language and the considerations end up broadening out from that considerably and getting into the very issues that you say is outside of that box that helps you defend the convictions on their merits. But my concern is that it did substantially inform the sentence that was imposed, and that creates some constitutional problems, and you don't get to ride both horses.
Well, I think it's a different forum, and
So at the point, I watched Brian's stream last night on this because I was sitting behind her, so I couldn't see her facial expressions. And in that Twitter space, someone was like, "Oh man, her face," and I'm like, well, I didn't even see her face. Like I saw her ponytail. So I went back and watched it last night. At this moment where he says you can't ride two horses, Brian like perks up and is like, "Let's go."
Yeah.
That was funny. Which is exactly what I was feeling in the room as well.
that really is. I mean, the rules that we have for the jury are different because
Absolutely.
And so I think that is the first part of my response. The other piece of it is, again, she made it relevant by spending. She had a slideshow. She spent pages and pages going on about this. How is the court supposed to just ignore that? I mean, of course, it's going to be, the court is considering, it has all its considerations in front of it, and it references.
Does she hear herself?
She doesn't have any remorse.
So bad.
In fact, she's standing up here and doubling down on it. So I think the court, and I see that I'm out of time, so I'll finish there unless you wanted to.
No, I think this is important territory. But it's one thing to say, look, she said this and I don't agree, but then to impose additional, or to make it part of the calculation as to whether or not you're going to impose the length of the prison sentence, to me, just because she raised it means that the court can comment on it as to whether or not perhaps it's persuaded or the like. But my concern is that the court didn't say that she's engaging in all of these hoaxes and she's undermining public confidence and she's doing all of these things that I think are very detrimental to society, but I'm not considering those for purposes of sentence because she is here on these convictions and that is the exercise of her First Amendment rights. Instead, I'm going to impose the sentence based on this. So we can address it and reject it. But what my read of the transcript is, the judge considered that and it went into the calculation of the sentence, and that's a First Amendment problem. Can you disabuse me of that concern?
Well, I think the court used strong language and addressed that. I think the court, I mean, again, as I've said, it's the context, but I think if you look closely at the transcripts, the court did lay all that out and then say, but at the end of the day, I think that might even be the quote. At the end of the day, this is about what you did. You violated these security protocols. You had a duty to enforce the security of the elections, and instead you violated it. So he ended up, that was the basis of the
But counsel, this was not about a security breach. This was about misleading public officials to conducting a trusted build in the presence of other people. She wasn't charged or convicted with a security breach. And so that's still beyond the charged conduct and the convicted conduct. I mean, did she try to make it relevant? Yes, but the court exercised its discretion, and you say correctly, to keep that out, but then it let it inform that broader picture, inform the sentence that it is.
And this is what Brian and I have said since the sentencing hearing. How can he do that? We said it. So Brian and Alpha and I did like 7 hours on Tina Peters last month or the month before. And it's one of the most egregious aspects of this that has been like, we've been dogs with like a dog with a bone on this. You cannot gatekeep her from being able to talk about any of these things. Consider that a rule of the trial. That's one of the guardrails you're putting in place, and then abandon it when it comes to sentencing her and consider all that stuff you didn't allow her to bring. And they did, and he did that, and he did it in a way. So this didn't come up, but in the sentencing transcript, he says, prison is the place where we reserve for people who are a danger to all of us, whether by the sword or the pen or the word of mouth. What? Prison is the place we reserve for people that say things we don't like? That's not true. Then after he said that at sentencing, he said, I'm at peace with everything that I've done in this case. I think he knew he was set up for being overturned on appeal. And Brian and I talked about that at the time that he sentenced her, because he seemed like he went all the way. He went hard in the paint during sentencing. We saw some of it at the beginning of the clip, but he did. It was vicious. It was vitriolic, and it blurred the lines. This is the thing the state of Colorado has done with this case that is maddening, and they did it with all the election denialism stuff. The legal parameters were very narrowly tailored so that they could control the outcome of the trial. And no one will, this is in my opinion, based on the information available, but nobody will change my mind on this because I watched it and I know these people and I know how they operate. But in the narrative, in all of the Jenna Griswold MSNBC appearances where she's talked about Tina Peters, all of the Kyle Clark, featured videos on the evening news about Tina Peters, all repeated this threat to democracy meddled with elections line. That is the story. Anybody in this state that knows about Tina Peters either thinks she's Joan of Arc or thinks she's Osama bin Laden. They believe that she meddled in elections. They believe that she tried to undermine elections, steal elections. That's never been true. It's never been true. It's always been narrative. And it was very encouraging and refreshing that the judges called it out yesterday. They were like, this is it. She's never been charged with any of that.
Yeah.
And
Do
that's what we've been
Tina's
saying for years.
attorneys just kind of like suck? Can we be honest about that? Like, are they not good?
Yeah. I mean, so there's a bunch of different factors at play there. So first of all, Tina's had a bunch of attorneys during this process. It's also very difficult to find attorneys in this state that will take election related cases. The Project 65 and all of that kind of stuff ran them off. So the ones that are doing it that will take elections, they haven't always been the best attorneys. I think that John Case, I don't know Peter Tickton, he doesn't really seem to be doing a lot of the legal work anyway. He's kind of like the celebrity attorney attached, in my opinion. So he went on Steve Bannon and talked about the pardon stuff. And in that first, they wrote that letter on December 6th about the pardon. We want you to issue a pardon. And then President Trump did issue a pardon, but it was actually issued before and all of that. When he was talking about that, he said, this is Stephanie Lambert's legal work. This is, she's brilliant. Right. She's being persecuted.
That's Patrick Burns' attorney, right?
It's Patrick Burns' attorneys.
Notable.
But he basically said, it's my name on it, but it's Stephanie Lambert's legal work. Now, the reason that the Patrick Byrne cases, Dominion, Eric Coomer, those cases haven't been heard, as I understand it, is because he's challenging in the appellate courts, and there's something that's going to be decided on this month, I think. Patrick Byrne is challenging Stephanie Lambert being disallowed as his attorney. So those cases, the merits of the Dominion case, the Coomer case, the merits of those cases are on hold while the courts deal with whether or not Stephanie Lambert can be Patrick Byrne's attorney anymore.
He wants her to be, or
yes, and she was disqualified.
Why?
For the criminal probe stuff that she has going on in Michigan related to the Darleaf records and all that kind of stuff. So she has stuff so that she was disallowed from being his attorney, and he's challenging that. So all of that whole case portfolio is on hold dealing with that. She is sort of practicing law in this case, right? She's according to Peter Tickton on Steve Bannon, she's the legal strategist behind the pardon theory. But we haven't really seen anybody argue. Peter Tickton argued a little bit in the federal habeas, but not a ton. It was mostly John Case, and John Case is, of course, the one arguing here. He's the one that did trial. She had a couple other people at trial too, but he's been her main counsel. John Case is a good man. He is one of the only attorneys that's been willing to engage with election deniers at all in the state of Colorado. And I think he did quite a bit of work early on at either severely lowered rates or for free. He's, been in the fight with the people in Colorado for a long time. I don't think his strength is arguing in court. There's a lot of different ways to be a lawyer, and being in appeals, especially, you don't get to present the way you do in a trial, right? You get to start what you want to say, and then they're going to jump in and they're going to question you, and they're going to ask you stuff that you're maybe not prepared for. You got to think quick. You got to have good recall on what's there. And I think he struggled.
I wish I could find free attorneys. That'd be fun.
Free attorneys would be great.
That would help. I do have like one more question, really. I mean, there's so much we could spend hours just talking about this thing.
And why we vote tomorrow. We will talk in greater length at this.
Yeah. So make sure you guys tune into that. That's at what time?
It's 7:30 p.m. Eastern.
7:30 p.m. Eastern. We'll probably talk about this on OnlyLands as well. But where do you think this is going? Like, what are the options? Are they going to completely get rid of the sentence altogether? Are they going to re-sentence her? Like, what are the appeals court's options in terms of how they address? Because they clearly see issues. They're going to do something, it feels like. But what are their options? What are they going to do? What do you expect them doing?
I think it's going to vary by charge. And I think that I think that, and I don't know, right, how this can really play out, because I think that the court established enough elements of a mistrial And so they can send her for another trial. They have asked for, that's what they want, by the way. Tina Peters' side wants a new trial in a different jurisdiction with the ability to bring the evidence. That's what they want.
They want a new trial?
Yes, they want,
Why would
because
they
they
not
want,
just ask to
because
throw
they
it
want to
out?
present the evidence of election fraud. That's what this has been for them all along. And I was told yesterday by her team they want a new trial. So
But if
John
you're
Case
like,
said that.
if
Go ahead.
you're Tina, why would you risk putting yourself through all this again? Like, is she being
Well, I think the
used?
condition would be, I think that she would be out pending that new trial. She wouldn't be waiting
Well,
still in prison. Yeah.
Well, yeah, but still, like, I almost feel like she's being used by people to try to
Yeah.
get this evidence in there. Like,
I've used the word traffic. Yes.
Yeah.
I think that Tina Peters and her story has been trafficked by a lot of people with different agendas that have nothing to do with justice for Tina Peters.
man,
Yeah, it's really unfortunate, but it's 4 years of her life, 5 years of her life at this point, dedicated to what I truly believe that Tina Peters believes that she is working in the interest of getting free and fair elections, right? Resolving the election issue. That's her goal. That's her true north. That's what she's working for. I don't think she's going to let that go. I've even heard that if Jared Polis commutes her sentence, she's going to deny it because
Why?
that locks in the conviction. Yeah, so it's gonna get even weirder.
it's already
But
pretty weird. But anyway, what are the
already pretty
options? So Tina's
Yeah,
side is
so-
asking for a new trial.
So new trial is what they're asking for, a new trial in front of a different judicial officer. When John Case brought that up yesterday, the court said, well, what if we're just talking about a resentencing? And he said, well, we're asking for a
The
new
judges
trial.
brought that up?
The
Or
judge said it, yes.
Okay.
The middle one, Judge Welling. Now I'm hungry and want beef Wellington. He said, what if it's just resentencing? And John Case is like, well, we want a new trial. He's like, no, I get that. I get what you want. But if it's just resentencing on these charges, you want it in front of a different judicial officer. And John Case said yes. And then the judge wrote it down. So that's an option, I think. But I think that option is for specific charges. I think the misdemeanor felony thing gets thrown out. I don't think they can do anything with that. Right. And I personally think, based on the way that our criminal justice system is supposed to work, that should throw out the whole thing. The fact that they messed up in that specific way and misinstructed the jury, the bias in front of the jury. And another just proof point, this didn't come up, but it's for everybody's understanding. The one area where Tina Peters brought in evidence that was not seen or approved by the court or the state, because they really controlled this process, as I've said, is with Jerry Wood's identity theft. So there were 3 felonies related to the stealing of Jerry Wood's identity.
They brought Patrick Burns guy too, wasn't it? Who did that?
Conan Hayes.
Yeah.
Yeah, they're old surfing buddies, as I understand it. So they brought in, because it was rebuttal, it was to impeach a witness. You don't have to disclose evidence that you're using to impeach a witness. So Jerry Wood was the witness, and they had these signal messages that showed that Jerry Wood was in on it. He knew his identity was being used, and he offered it up, and he was a part of the plot of deception. But the state's position was that he had his identity stolen and he was a victim, right? That was presented as impeachment evidence, so the state didn't know it was coming. On those 3 charges, she was acquitted. So where the guardrails of this were not controlling, and Tina Peters was able to introduce evidence about why she did what she did, her defense, able to introduce evidence that the state wasn't able to approve or deny, she was actually acquitted on the charges. And that's why I think I don't think you can split this baby, right? There's 7 convicted charges. I don't think you can split them out and say, well, these conviction holds on. The only 3 I think you can do that on is the 3 felonies. And the only reason for that is that she stipulated to that before the trial started. So she stipulated to the felonious conduct of representing Conan Hayes as Jerry Woods to the 3 people. Those 3 I think can stand, but would be resentenced, in my opinion, because they're way too harsh the way they were sentenced originally. I think that could happen. The messed up charges get thrown out. One of the felonies, one of the misdemeanors get thrown out. She gets resentenced on the remaining charges. She gets time served. She gets out. I don't know. There's a bunch of different ways this can go. And then there's also all the federal investigation, DOJ statement of interest kind of stuff. The feds are not disengaged from this case either.
Yeah.
And this case ties to the investigations they're doing into funding, into prisons,
Yeah.
into elections, into voter rolls, into weaponization of government. They did weaponize the government here, and we're going to prove it. And I'm super excited about it.
I just think it doesn't make sense. Like, you're appealing the case, right? You're not appealing the sentencing. Like, why would you even?
It's part of it.
I know, but
They are appealing the sentencing. The sentencing was overly harsh. It's cruel and unusual. It's Eighth Amendment is what they're invoking on the sentencing.
Gotcha. But wouldn't that be a loss though if they just re-sentence her and not move forward with like the actual appeal of the merits of the case and whether or not she should even be in prison at all?
Yeah, but that's the problem that she has, is that so the question is not the attempt to influence a public servant statute, which is the 3 felonies we're talking about, and the 4th one, but that's the one with the misdemeanor problem. So I think that goes away. I think that's going to get thrown out. But the 3 felonies of criminal attempting to impersonate or attempting to influence a public official do not require intent. The statute does not have an element of intent. So it doesn't matter why you did it. It's did you do it or did you not? Did you lie to the public official or did you not? And the problem that she has on those 3 charges is that the trial has nothing to do with whether or not she did those things. They didn't have to find those facts at trial because she admitted to doing it before trial started. She just thought she was going to be able to present evidence of her intent and why she did it. And she was not allowed to do that. And I think she probably should have known that she wasn't allowed to do that because that was all matter of pretrial stuff that happened beforehand. The judge disallowed that stuff before trial. But those 3 felonies, I think it's hard because she stipulated to the actual felonious act and there's no intent requirement. I think those convictions might stand. They didn't even have on those 3 charges. They did not have to have a trial. Because she admitted to the actual crime on those 3.
Do that.
Terrible fucking lawyers, John. Sorry, I'm trying not to curse and I failed.
It's okay. You can curse. The swords are only.
I know, but I'm trying not to. For me, not for you.
Well, I think for everybody, you should be allowed to curse. We like when you curse.
I just think I do it too much, though.
That's okay.
In the middle of the day. It's not OnlyLands.
Okay. Well, I think we'll let you out of here and we should talk. I mean, obviously, you guys should all watch Why We Vote tomorrow. We'll talk about this probably on OnlyLands. This isn't going away. This is a very interesting scenario. Were you expecting it to go the way it did yesterday? No. In fact, when I was waiting in line, I was like setting people's expectations. Like, do you think she's going to get out today? And I've gotten to the point where I just kind of lose my mind when people ask me that. Like, no. Yeah. Like, no, that's not how this works. It's literally not how this works. Yeah. Even if they did say she needs to get out of prison, it probably wouldn't be today, right? Because they take time, the paperwork and the process and all of the things. I thought that in no universe did I think that the greatest advocate for Tina Peters in that courtroom was going to be the Colorado judges. It blows my mind. Yeah. So no, nobody was prepared for this, including the state. And you can see that all over her face in the hearing. I think they thought that they had kind of a slam dunk situation. And, we're told, how many times have you been told, John? Jury convictions are notoriously hard to overturn. You can't do it, right? Unless the state misled the jury. Yeah. And that's where we're at right now. So okay, I do have one final question. Yeah. If they do a retrial, can they do the retrial on a broader scope where they can use that other evidence? Or do they have to retry on the same specific narrowed scope that they were supposed to do in the first trial? Oh, I think they'd have to retry on the same charges. It'd have to be the same charges. I think the evidentiary rules the evidence decisions by the court might be reset in some ways. So they'll make decisions about specific pieces of evidence again. Those decisions won't stand, right? Like the judge's prior calculus won't stand, but I think the charges would need to be the same charges. So even if they did a retrial, would they be able to bring in the election evidence that they want to? I don't think so. So then why are they going for that? Unless it gets to those 3 felonies and they are allowed to talk about her intent for why she misled everybody about Conan Hayes being Jerry Wood. And that could, get her, she could get acquitted on the 3 felonies. It's possible. I still don't think that gets you to getting the broad, you're not talking about Mesa County findings.
in that instance. And they designed this case that way on purpose. They did not want to open those doors, and they fought tooth and nail in pretrial and at trial to not allow those doors to be open to talk about election fraud. So I don't know that it's the case, right? Like what you're asking is this the case where we can actually get the Mesa, for example, the Macy County stuff, those reports, the findings of those reports into court? I don't know that this is the case because of the way that the state defined it. So if they do retry it, you're still trying on the same charges. Can you let the evidence in to prove her intent? I think another judge might rule the same way, because the statute doesn't require intent. They don't have to prove intent. So, it's risky calculus. And, but I do think, just my final thought, I do think that they will give her relief. I do think Tina Peters gets some form of relief as a result of this. I think some of the charges get resentenced. I think some of it gets thrown out. I think the judge should be sanctioned. I don't think that will happen, but I do think she gets some relief on this. Whether that means she gets out immediately, I don't think so. Two, I'll just leave it at, I don't think so. Be great if it happened, but I do think that we're getting closer to her getting out sooner, way sooner.
Which is good. Yeah. Is there a timeline for when the appeals court will respond?
No, it depends on the complexity of the case, the urgency of the case, the different factors involved. If they need to do more research, if they need to do, there's a whole bunch of things at play. This one, I think the urgency factor plays, right? Because if she's unjustly incarcerated, that's a big deal in our criminal justice system. So that may actually play and make it more urgent. But the complex issues, and specifically, we didn't talk about the Constitution, the pardon and the constitutionality of it yesterday, but it's still before the court. And that still is something that Peter Tickton has said. He's done this in the way that he's done it because he wants this case to get to the U.S. Supreme Court as quickly as possible. And that's why he did this the way that he did it with the pardon. So if that's true, then I would still expect that he would, when they say, no, we have jurisdiction, this motion is denied, I still think he's going to appeal that no matter what they say about the merits.
Well, that was going to be my next comment. Actually, question is, okay, so whatever ruling comes down, both sides, either side is going to appeal. So the next step above this court, is that SCOTUS, or isn't there one more? U.S.
Supreme Court. No. So the jurisdiction question can be decided. So the review of jurisdiction can happen once, as I understand it, in the state. So it could be the Colorado Court of Appeals reviewing jurisdiction, or it could be the Supreme Court, but it can't be both of them. It can be done once at the state level. So this court is empowered to review jurisdiction. It sounds like they're going to, and they're going to rule on that motion. So appealing that goes to the U.S. Supreme Court, not to the state court.
Gotcha. Okay.
Yep.
Well, Ash, I appreciate you joining me for this.
My pleasure.
And everybody tune in tomorrow, Why We Vote and Only Lands. We'll be talking about this stuff. Great job covering it.
Thanks.
It's been
Thanks,
killing
guys.
it.
See you later. Bye.
See ya. All right. And that was an easy show. I didn't have to do anything today. I have a whole bunch of tabs all ready to go, and we're out of time. And I have to actually sign off now because I have a phone call I have to make here in 2 minutes. So I'll keep all my tabs unchanged for tomorrow, and we'll go through and I'll see if there's anything else I want to talk about. I guess technically it'd be from whatever. We'll figure it out tomorrow, guys. Thank you for tuning in. Make sure you give Ash a follow, CanCon a follow. They are doing some great job covering this stuff. I'll be back tomorrow on the Daily Herald here, 1 p.m. Eastern. Hit the thumbs up. See you guys later. There were no rants, so I'm not going to read any rants. How long does a decision like this usually take? I don't know. Thanks, John. Thanks. Okay, yeah. Thanks for tuning in, everybody.
Let's get started. That's what she said. Oh, that's real good.